No, the points have been covered by my colleague from the Barreau du Québec and the Canadian Bar Association. Ms. Jafari, you now have the floor.
Thank you. Good afternoon. I'm here on behalf of the Canadian Muslim Lawyers Association. My name is Pantea Jafari. We represent, of course, Muslims all across Canada at varying immigration statuses, whether they're citizens, permanent residents, or have been invited to Canada as visitors, workers, and students. We also represent a wide spectrum of people who are covered by the brush stroke of Muslim in the post-9/11 era, which is a vast majority or a vast population amongst those residents in Canada that would be subject to this bill. Everyone that has testified before the House Committee as well as this present committee is unequivocal in relaying the fact that this bill does not have any teeth in terms of fundamental protections for the rights of those in Canada. The very protections that the Prime Minister and Minister Goodale are espousing is the main benefit of this bill. So the bill is being introduced under the auspices of course, the Americans can do what they want, but here we have the benefit of being on Canadian soil with the protection of the Charter and other Canadian laws. And as the Commissioner testified, as a plethora of legal organizations testified at the House Committee reviewing this bill, and as the rest of us will be testifying before you today and on the next panel, that is fundamentally just not the case. And with that not being the case, you have to wonder what's happening, what's the reason for it. So when Minister Goodale opened discussions on this bill at the House, he testified that everything was going great. The U.S. was very satisfied with the pre-clearance areas. There were no issues. They were so happy indeed that they were looking to replicate this in other jurisdictions around the globe. They were very happy with the Canadian model. Things were going great. They want to expand it. And the previous or the present version of the bill also has a sunset clause. It has a review mechanism. It mandated a review every 5 years. We haven't been told, we haven't been presented any tangible evidence that suggests the U.S. is saying that they cannot perform their duties, that they cannot protect their borders without expanded powers as enshrined in this bill, the expanded search and seizure rights, the expanded physical strip search rights, the expanded questioning rights, the limitation on the right to withdrawal. None of this has been proven as a necessity for the continued operation of pre-clearance areas. In fact, like Mr. Green said, the minister said 60 years of smooth sailing. So what's going on? Why are we doing this? I understand that there's a great benefit to be had by the expansion of pre-clearance areas throughout Canada, as well as to its expansion to trade and commerce and transport. But we have to be really mindful at what cost we're willing to gain those advantages. And unlike the rest of the organizations who might more in a politically correct way be able to sit here and tell you about the deficiencies of the bill, which is outlined very thoroughly in our written submissions as well, and echoed by the in the House Committee, for example, we made a joint submission of a summary of all of our key briefs between the National Canadian Muslims, the International Civil Liberties Monitoring Group, and the Canadian Muslim Lawyers Association. And we outlined that the fundamental flaw in this bill that is undeniable and palpable is that it doesn't have the mechanisms for recourse. And when that's being done in an era where we have the most palpable litmus test of the fears that we should be considering when considering ceding powers to such an extent, it's really disheartening, it's really concerning, and it's very alarming. The populations that our organization represents are going to be undeniably the most targeted by any changes on the pre-clearance areas. When President Trump says extreme vetting, and that's what's happening already, and that's leading to mothers wanting to buy toys for their kids across the border being questioned to no end for 6-7 hours and then being denied entry. When this morning we hear of a writer and a reporter in Ontario being questioned for 2 hours on end, missing a flight, later coming by to catch that flight and still being questioned. when these are happening under the present Pre-Clearance Act, we cannot deny that any changes to it in the form that we're proposing under this bill is going to be felt disproportionately and discriminatorily by racialized populations. So we're seeking to gain an advantage, economic advantage through easier trade, easier movement between the borders at the cost of significant civil liberties that are going to be disproportionately applied to sections of the population. Not everyone's going to see these downfalls. Of course, the average citizen might be able to just have a few questions and enter. People who are waiting at border crossings right now might actually have a benefit that now that's with pre-clearance it's going to be shorter. I actually recall at the House Committee, a member of Parliament had explained how it was very frustrating for her that she was, at a crossing at an airport for an exceptionally long time, and how much better it would be if we had these pre-clearance areas, and that would be a much faster transit for her. I agree, for some portions of the population, those benefits will be had, but we cannot deny that for a great portion of these populations, racialized populations, who are already over-policed in their communities, who are already disproportionately scrutinized at the borders, who already feel threatened by people in authority, they are going to be at these borders without the right to realistically withdraw, and who are going to have heightened frustration every time they have to choose between the benefits gained by going to the U.S., whether that's in terms of attending family events, attending work functions that might be necessary for them to keep their jobs, between that and feeling the indignity of being questioned to such an extent that they feel like they're being treated like criminals. This is a reality that's happening. It's already happening. And we're only going to exasperate that by expanding these rights, who, again, we've received no evidence need to be expanded, without any ability to meaningfully have recourse to where those rights are violated. So many organizations have testified that through the intersection of the State Immunity Act and the provisions of the bill itself, there is literally no meaningful or viable opportunity to remedy any wrongdoing by a U.S. pre-clearance officer, save and except for where there's death, bodily harm, or damage to property, and only then are you allowed to potentially sue the U.S. government only. So that officer will still not necessarily have any liability. An average person in Canada, whether it's a citizen, permanent resident, or a temporary resident trying to travel to the U.S., would have to take on the U.S. government, and can only do so if they are in a situation of death, bodily harm, or damage to their property, for them to have any sort of recourse under this bill. That is extremely problematic and alarming. We're now at the Senate stage. We testified to all of these things at the House stage. And though I'm happy to see some changes in the bill coming out of the House, especially, for example, there was a 5-year review put in. We're very grateful and we're very thankful to see that. But there's really nothing done regarding the core dysfunction of the bill, which is the lack of accountability. What I notice coming out of the House is that Section 26(1) was added. With all due respect, this is just window dressing. It's a glorified comment card. The section literally says, and Senator McFadden read this out earlier, a traveler may, in a prescribed manner, inform the Canadian senior officials. What does informed mean? You literally get to tell somebody that I felt violated.
Madame Jafari, malheureusement, je vais être obligé de vous...
Ms. Jafari, unfortunately we'll have to stop there because we only have 30 minutes ahead of us and senators would like to ask questions. No doubt during the Q&A you will be able to continue your explanation. I will hand over the floor to Senator Boisvenu. Thank you very much, Mr. Chair. I just want to make sure that our guests are listening and hearing the interpretation. And so welcome and thank you very much for being here. Your presentations were very, very interesting. Also very, very concerning at the same time. My first question is for Mr. Green. Is this bill a step in the wrong direction as compared to the bill from 1999?
Yes. Yes, it is.
Ben, à vous entendre, j'en ai la confirmation.
Well, I just got confirmation from what you said.
Yeah, no, it's I think probably necessary from the government's point of view that it's much more comprehensive. The new bill is probably 4 or 5 times as long as the old and has a lot more provisions, particularly around liability of officers and criminal charges against officers. That seems to be a major focus, and also the ability to expand to land crossings and sea crossings, and I know that we have economic interests like Billy Bishop Airport and Quebec, and that very much want to expand pre-clearance areas. But my feeling now is that the more I've been immersed in it for quite a while now, it seems worse and worse. Just this lack of any kind of recourse and any remedy. Once we let those horses out of the barn, I don't know how we get them back.
Mais à ce moment-là, est-ce que vous avez l'impression?
But then, at that time, do you have the impression that this bill was dictated by the American authorities rather than by the Canadian authorities?
That it has all the hallmarks of the first bill, which is it was written by, I don't like to use the term bureaucrats, but people in the administration who wanted to achieve their own ends. And, from the Americans' point of view, it would appear they want to have the same powers they have at a port of entry when they're on American soil, which is basically, and it's going for a maximum power with minimum accountability.
Donc, on consacre vraiment dans le projet de loi.
So in the bill, really, they are on Canadian soil, but there will be parcels of that soil that will be entirely American.
It's not supposed to be that way, and that was what it made it in the previous bill, which I think was C-22 when it first came in, but it's the 1999 Pre-Clearance Act. They went out of their way to make it clear that this, because it wasn't clear in their first draft, that this is not U.S. soil. It is definitely Canadian soil. But in what is happening, I think you're correct, is that, if I've got it right, is that de facto it's becoming American soil because of the inability to enforce any Canadian law.
I'd just like to add, if you don't mind, that it's the equivalent of renouncing Canada's national sovereignty for this passage between the two borders, the two territories. That's what it amounts to. And really, it is a bill that is going to endanger some fundamental issues where there should be a fundamental notwithstanding clause, and it's an affront to Canadian sovereignty. Well, it strikes me that it's an absence of the possibility of appeal, an appellate court, yes. So a Canadian in an airport who it comes before the American authorities would, in a sense, be captive. The Canadian would lose his right of appeal. If there is harm done, injustice to his rights, there is no possibility of appeal. Nothing is provided for in the present draft of the bill. There is no appeal. And any conjecture possible, of course, you could say there might be 400 and some different issues, but will that translate it into a remedy before a court of appeal? But has this not been, could this be brought up to the Supreme Court? Well, we could always formulate an application to the Supreme Court in the hope that it would rule favorably, but is it necessarily a decision that would be necessarily favorable to us? Well, politics enters into it, and as well as law. So really, there is subject to challenge this, I would say. Thank you. Senator Brazeau.
I guess my question is more towards Mr. Green with respect to when we're talking about the unrestricted right to withdraw. do you think that this bill is essentially the government offloading its responsibility, perhaps to appease the U.S. government and its position on, or I guess its views and positions on security?
Yeah, I don't know that that was the intention. I would like to think that our representatives were just blind to the issue and didn't realize. They thought if you put this provision that says the charter applies, everything will be fine. But it's a curious way to make law, and that is that the governments get behind closed doors, they come up with this agreement, they sign this agreement, and then they present it to Parliament and says you can't change it. And now we'll do consultations and invite Canadians to come and speak about it, but we're being told, it doesn't matter what you say, we can't change the agreement, so you're stuck with it. So certainly the net effect, in our view, is that they have offloaded the responsibility and done a poor job of protecting Canadians' rights in it, and that this bill is seriously flawed because of that.
And potentially communicating it?
Sorry?
And potentially communicating their position on it?
Mm-hmm. Yeah, they may, if they had a position, well, it wasn't effective. And remember, it was a previous administration in the U.S., which in theory would have been much friendlier to our point of view. But I'm not sure it really works that way. And I don't think this came from the White House. It was I suspect, just the apparatus of the border services agencies. We have to remember, we're doing a lot of cooperation with the Americans now. We're doing a lot of information sharing. We're doing a lot of working quite closely together. So I suspect it came out of that process of those agencies, what works for the agencies, except that nobody considered Canadians' rights in the process, or it seems like they did.
Thank you.
Senatrice McFedrin.
Thank you, Mr. Chair. I'm going to page 19 of your brief and to the summary of recommendations, and then I'm turning over to page 20, and although I have many questions, I would like to focus and ask you to clarify a bit more the vision around number 8, recommendation 8, which I think is a little unclear, at least to me. 8 reads, a working group with representatives from the CBA, Justice Canada, and CBSA be created to collaborate in the development of a defined policy for searches at the Canadian border that involve information protected by solicitor-client privilege. So I have a number of questions about this, and I do want to invite those representing organizations in addition to the CBA to make suggestions or comments. Here are my questions. First of all, what is the timing that you see as ideal for this working group? Second of all, why did you make this as narrow as solicitor-client privilege? Third, for the findings of the working group, what do you see in an optimal rights-focused process? What would happen to those findings? Who would engage with those findings? And how would the work of the working group potentially lead to any actual changes in the law?
Okay. A lot of questions. I'll try to remember them.
But all related to this one recommendation.
No, I get it. So we had this was a brief prepared by a committee, and you know how that works. So I can, but I think I can speak pretty well to it. This is a part of a larger issue. It doesn't just affect pre-clearance areas. It's the one the government is grappling with right now in Bill C-21. The same issues are coming up in different places. And Mr. Tehran referred to these issues that we have to be clear in Canada. What is our policy on how we handle electronic devices? And as I said, not just on the devices, but what's on the cloud. And then how do we handle solicitor-client privilege? So when they take my device at the border, I can tell you it's filled with correspondence with my clients, a highly confidential correspondence, and I would not want them copying that correspondence and sending it off to Washington where it will never be retrieved. So this happens at ports of entry as well. When you're coming into Canada, we need to be clear on our policy. We have to develop those policies. So we're saying, in this, we want to be invited to the table to help work on those policies, rather than presented with these fait accomplis where somebody hasn't done their consultation and just I think, probably innocently missed a few issues.
When do you want to be invited to the table? The timing of this
In
is
advance.
unclear.
Yeah, well, I think it should be going on right now because this technology is evolving so fast and our ability to capture information is evolving so fast. But let's just look at Bill C-21, which is before Parliament right now. That one's going to have a fundamental change to powers of customs officers. They will be able to examine people on departure and ask them all the questions they ask on entry. They're going to be entitled to do that. And so there's going to be more opportunity for gathering information and capturing this kind of information. We need to be clear on our policies. The Supreme Court has commented on electronic devices and is saying it needs a higher standard. And solicitor-client privilege they put up way up here in terms of standards. But the nuances of the information on the cloud and how it should all work, they haven't dealt with it, as far as I know, at in the port of entry context. Now, Senator Jaffer, I read her remarks, and she talks about these, and she specifically refers to some cases, and saying, we need to be careful about this kind of thing. But this is, I emphasize that recommendation is a broader context of what needs to be happening with port of entry and the capture of this kind of information. So it does affect pre-clearance, but it's because we are saying the Americans have to apply Canadian law. So that means our interpretation of Canadian law should be the policy our CBSA applies. Well, then that's what the U.S. Department of Homeland Security should be applying on Canadian soil in pre-clearance areas. But if we're not clear, how can they be clear?
Okay. So the answer to my question about when is right now, which would mean prior to adoption of the bill. Like right now, go into this in more detail, either through this process or another, but likely through this process here in this committee. And you're making recommendations to us on this. I get that. May I ask, when I said why just solicitor-client privilege, I didn't mean in any way to trivialize the importance of that. I mean, as a lawyer, I appreciate it. But what about 26.1? What about the emptiness of 26.1 and the lack of any other alternative at this point?
First of all, I think with respect to a solicitor-client privilege, that it is a power invested in us that is given to us by the client. So you understand that solicitor-client privilege, we hold it, we possess it, but it is given to us by the client. The vulnerability, yes, is us, but it is really the client who is vulnerable to that violation of fundamental rights. If we have things in our laptop, our PC, or telephone, or whatever, that can belong to us. But it is something that could be to the disadvantage of the client, and we must protect the client. That is, solicitor-client privilege is an essential fundamental in our society. That protection has to be assured. Now, when you leave Canadian territory and when you come back, because the same vulnerability exists at all times, there is no benchmark whatsoever with respect to the protection of solicitor-client privilege in one direction or the other. It's in both directions, and that is of great concern to me. This is why the Quebec Bar certainly supports what was said by the Canadian Bar. And with respect to 26.1, in direct answer to your question, well, it is an article that has words in it that are empty of meaning. Empty of meaning.
I think the question you're asking is, are there not equally concerning things that we should also be investigating at the present stage? And my answer unequivocally is yes. Because though the organizations before you and before the House testified as to these fundamental flaws, main one overarchingly being that there aren't any review or accountability mechanisms, to where we kind of lie on a spectrum is in terms of what would be required to remedy that. And for example, when the commissioner testified, he said in 26.1, if you added devices, mobile devices, that would be helpful. What I'm here to ask of you is that that's not enough. It's fundamentally not enough. To say that you can report to somebody just of a violation or a feeling that you've had without any legal remedy to be able to hold someone accountable for that violation is meaningless. It's, as you said, a right without a remedy. And because of that, although I understand there's no appetite to renegotiate the agreement that this is based on, it fundamentally needs to happen. That's the whole purpose of the legislative process. An agreement is formed, and then the legislature comes through and scrubs it down and sees whether there are issues with it that are, fatal, or amendments need to be made. If there are fundamental things that are missing from this bill that need to be in it, and your hands are tied because of this agreement, I think you need to recommend that the agreement be reopened. If President Trump can reopen NAFTA suddenly, why can't we reopen this agreement? If it's so fundamentally flawed that it's sacrificing the civil liberties of all Canadians, but that we know are disproportionately and discriminatorily going to be applied to a portion of Canadians, then why would we go down this road? Why not halt the train before it gets even worse? Because once you cede that power, and again, it's unprecedented power, to cede our sovereign rights and to suddenly essentially form U.S. soil on these pre-clearance areas is unprecedented, and it's something that you're not going to be able to rope back easily. We're standing at a cross point right now where we can actually do something about it.
Second round, Senatrice Griffin.
Thank you, Mr. Chair. I have a couple of questions. One